Can I copyright an idea?
No.
So what can I copyright?
Original works of human authorship, which is basically what I would say is your expression is copyrightable. So that piece of whatever you've made it is itself protected. But the other pieces that are not would not be protected.
Well, wait, you can't copyright an idea, though. Give the audience an example of an idea.
An example would be the idea of a wizard.
Okay.
Yeah, I had that one early, I just want to say, But what is the difference between a copyright and a patent?
The difference just has to do with the subject, like the things that are covered. So copyright is really about works of authorship, and patent is, generally speaking, just about inventions. And so sometimes there's overlap. But for the most part, if you think of something like a book, that's going to be copyright. If you think of something like I've made a new way to make a widget, that's going to be a patent.
With artificial intelligence, we have these large language models. So Sarah Silverman can say, well, I looked at all these jokes that were my jokes, and it got trained on these jokes, and it wrote another joke and then checked it with other kinds of jokes. How can we have the wisdom of Solomon for Sarah Silverman and know whether she's got a legitimate case or not a legitimate case?
One of the difficulties with this is that a lot of people talk about this as sort of things like style. So what you're saying right now is maybe a different kind of comedian has a different kind of structure of a joke, or an artist has a certain kind of style that you see across images. That is not actually copyrightable, right? So it has to be its particular expression. So if you saw the actual verbatim expression from somebody's work that we will just assume is protected by copyright in an output, that would be one thing. But it's another thing if you have an output that really has none of that expression at all, but it sort of reminds you of it in some other way, then that's not going to be a case of infringement in the output, even if we would all agree that it was sort of trained on copyrightable material that sort of bears some resemblance to that output. That's a general problem, like a difficulty with some of these cases with the outputs.
If I want to be a comedian,
don't you?
Well, if I did,
okay,
I could observe all of Sarah Silverman's jokes. She could make a joke about a house and her family, and then I could make a joke about my family. My joke is totally different, but how is that different than a large language model writing a joke that's based on reading all of Sarah Silverman's materials?
So as you said earlier, right, I think the argument is that we don't really know how these things learn. And the way that you or I are going to learn something like that is going to be different from the learning that is happening for a model. An LLM at the end of the day is just predicting the next word in a line, right? That is not at all how you and I learn, right? And we don't need billions and billions of pieces of training data because we just have an amazing ability to abstract and sort of have these sort of inductive powers that a computer program does not have. So what it's doing is it's seeing all of the content, all of the jokes in the history of time, and then giving something, and then maybe you can direct it in certain ways. But that is different from human learning. That's not to say that you can't call it learning, but I do think that there will be a difference when you think about what do we really mean when we're talking about learning. But to the extent that learning just means you're using a bunch of stuff and you're extracting from it some sort of information or understanding, then as long as we just understand that what that means for these things is radically different, but ultimately it's going to allow it to do what it wants to do, which is sort of predict the next thing, then I would say that those things have some parallels.
If you have a baby and you show a baby a horse in a field, the baby miraculously can interpret for the rest of its life that that is a horse in all sorts of different situations, right? They learn in ways that we can't even really understand how a baby learns. Although it's funny because we actually emerge from the baby, later. But a large language model can't do that because it couldn't do the simplest possible part of that. It doesn't really reason, but it can have some particular insights. How do we get the Copyright Office to understand this difference between a machine and a human being? I mean, we have this definition you talked about, well, it's not a person who's alive, but don't we need more to build law on top of?
On the point about how babies learn, which is, I just think, super interesting. So there are these more sophisticated models, and one of the things that makes them more powerful is the fact that they are able to figure out relationships that it's very hard for us to tell it to understand, right? So AI vision is an example, right? Eventually it figures out that these trees or humans, they look a lot of different ways, but I don't want to hit any of them when I am driving this car, right? And so it will be able to deduce those things. It's not like people who are training those showed it a picture of every single person on the face of the earth, right? So at the end of the day, it's an ability to make some sort of inductive inferences and understand sort of what concepts are in a way, speaking loosely and sort of anthropomorphizing it a bit. But it just depends on the kind of model, and it depends on what it's understanding. But for the copyright purposes, there are issues on the infringement side, whether or not training a model is infringing, when are outputs ever infringing, can the model itself be an infringing derivative work, etc. And then there's a separate question about sort of ownership. What is the status of outputs that we all generate using these tools? Can I be the author of that output, and can I receive copyright protection for something that I create using DALL-E or Stable Diffusion or whatever? The infringement question is primarily being driven right now in a bunch of litigation. But on the ownership question, what I think is the most interesting and hard part of that is just understanding what we think it really means for a human to be an author. Because you think of all of these different kinds of cases and different kinds of artists who make art in ways that press on the boundaries of what we think is happening, right? If I just sort of throw paint at a canvas, I might not have any really good idea of what it's going to look like, right? If I'm a photographer and I set up the camera in whatever forest and I let it take pictures for me, I have no idea what it's even going to be a picture of. Do we think that you are the author in all of these different circumstances? In a lot of cases, minus photography, because the invention of cameras and that whole thing, led to a Supreme Court case that was quite important for what we're doing now. But most of the time, we don't really think about it because we just sort of accept that if you were holding the paintbrush or the paint bucket or doing, whatever, you're the author. And this is just showing us that actually we don't have a very good theoretical understanding of what we really mean by that, and if we can think of necessary and sufficient conditions for finding authorship.
What is the difference between a paintbrush and a large language model? Ultimately, if I'm an artist, isn't it my interpretation in either way? One, I'm using my hand to manipulate paint. One, I'm using my mind, and fingers to hit keys.
Yes, Chris Castanova actually put in an application a while back for Zarya of the Dawn, which was this comic book. And the images that were used in this comic book were made using Midjourney.
But the words that were all over it were not Midjourney, right?
It's just the images, you're saying.
Yeah.
Yeah.
Okay. And, went through a lot of work to do that, because back then especially, it was really hard to get it to have the same character over images. It just wasn't designed for that. It's much easier now.
Sure.
But the concern that the Copyright Office had was that they sort of saw it, I think, as sort of like a slot machine, right? I put in a few words. I have no idea what's going to come out, right? I mean, I have a general idea, right? Maybe I know the idea of what's going to come out because I said, I want like a teddy bear or a capybara or whatever it is. So I might know that piece. But when it comes to the expression that's included in what comes out, for most people, you just don't know. And that raised the question of whether or not, is knowledge ahead of time part of what it means to be an author? And then you'd say like, well, no, like most artists have no idea, in the process of creation are understanding what it is that they're making. It's not like you have this idea in your head ahead of time and then just sort of create it, right? But that's their view. Their view is, and has been, that we should treat the tool kind of like you would treat an artist that you were commissioning. And I may, when I commission an artist, say, oh, yes, I would really like you to create me a picture of my dogs. And I would like them to be, sitting by this tree. And I give them some general ideas, which is supposed to be analogous to the prompts. And then the artist goes off and actually makes a picture. And all of the expressive choices were really by the artist. And then that's the work. And we aren't going to say that I, the one who commissioned it, is the artist, right? I'm not the author. The copyright in that commissioned work is surely going to be in the artist, right? And so they are saying, this is just the same. You're basically commissioning to Midjourney this work. It sort of makes all the decisions, and then that's what you get. And so, no, you're not the author. That's the position that they have taken.
But Midjourney has taken other people's actual intentional expressions, put them in something, and therefore they don't even have the original idea, right? So how can that be the point of view, the Copyright Office?
Well, the Copyright Office point of view is that there is no author, that these works are immediately in the public domain. There haven't been any cases yet that I'm aware of where the creator of the model has come forward and argued that they are the ones who are the author. I mean, I'm sure this is going to happen, but that they are because of the choices that they made in creating the model and then the tool overall. They're not making that. But what you would say, I think, if you were the creator of the model, is that you made all of the creative choices in creating that decided what was going to be learned from the training data. What kinds of things did you do in order to decide what kinds of outputs could be created?
Yeah.
There are lots and lots of creative choices that are made. I mean, tons of creative choices that go into making these things.
But taking this example of the comic book artist themselves writes the words, but then it also says, okay, there's a panel. The first panel on the left is going to be this image. It relates to the second image in this way, which strikes me as it is an expression that in and of itself should be copyrightable, no?
Yeah, so the Copyright Office made a distinction with Daria the Dawn between copyright in the images themselves and then copyright protection for the compilation, basically of the images, the text, and basically how Chris decided to arrange them. So you can have, and the Copyright Office is fine with this because this is what happened there. You could have the copyright in the compilation. The problem with that is that compilation copyrights are what you would think of as like a thin copyright, because what it really means is that the only way that I can realistically infringe if you have a compilation copyright is if I take the entire compilation. But if I take a piece out of that compilation and use that in my work, that's not infringing your copyright you have for that. And so it's not very satisfying if you, for instance, don't want people to use the images that you generated using Midjourney. That kind of a copyright's not going to be able to help you there because it just doesn't apply to the image itself.
So there's this case with Scarlett Johansson suing because somebody took her likeness and replicated her voice. We don't know exactly what the instructions were to create this ad, but it's an artificially generated image of her, and then it's a artificially generated voice of her selling something. I don't even know what it is. But where do we think that is going to end up in terms of copyright?
Yes, I'd heard a little bit about this case. I had heard, and I feel that I just looked this up, that some company just took a photo of her, like an actual photo of her, and used it in an ad for a tool that happened to have an AI, right? Which ends up being related to AI in the sense that an AI company perhaps did this.
That's just copyright infringement.
Well, so it's very unlikely that she has the copyright in that image, right? So I think that is another thing, which is there's one particular image. There can be lots of different rights that are in play. One of those rights is going to be the copyright, and that's just the author of the work. Then again, there can also be works within works, right? This is why when you do a movie and there's like a clearance of all of these things that you see in the movie and whether or not there's, all of these issues. But there's copyright in the work itself. And then when it comes to people, you have rights of publicity. Depending on the state where you live, this is a state law issue, but that in general is a right basically to stop other people from using your likeness commercially. So one of the things that has come up in the AI generated context is that most people are not really trying to make money when they're making these kinds of deepfakes or whatever, right? They're just doing it for fun. And so in some states, especially where commerciality is central, it's not clear that you actually meet the test for a violation of a right of publicity because the whole point is about exploiting it without you getting compensated. So that's one of the reasons why some people have been arguing for this federal right of publicity, basically a commercial use, as a way to stop people from being able to use other people's likenesses in works, even if they're not doing it for commercial gain, right? Just for their own benefit.
Corbis sued, I forget, one of the big, maybe Dolly or somebody, about taking millions of their images and putting them in and using them to train a model on how to create new images. Where do we stand on something like that? Because they do own all these images, but they don't own what the output is. If I had a book, I would be able to do whatever I wanted with the book, learn from the book. I could have ideas that were similar to the book. Where do we think copyright goes on an issue like this?
Okay, so copyright holders, usually when we talk about it in law, it's taught as a bundle of sticks, and each stick is a different right. And one of those rights is the right to make reproductions of your work, right? And that's why I can have a copy of Harry Potter, but I cannot just make copies of Harry Potter and distribute them, right? I mean, it doesn't even matter what distribution. I just can't make a bunch of Xeroxes of Harry Potter, right? So that's because the right that I got in buying my copy does not include the right of reproduction as a separate right. So in the training context, a lot of the litigation, the argument is that the scraping and then the use, the reproduction of works in the process of training a model, they are reproductions and they were not authorized. And so they are infringing. And the defense is that those are fair uses. So in the United States, and this is not true in other countries, we have this thing that's called an affirmative defense for fair use, which means that you basically can say, I know that I did something that would otherwise be infringing, but the law is not going to recognize that as infringing in this case, and it's basically going to be excused as a fair use. And so the debate on that question about whether or not the use of people's stuff as reproductions and training is basically infringing is it fair use? And that's the question. That's a separate question, though, from even if that was a fair use, that doesn't necessarily speak to what happens if in a particular instance there's an output that actually includes copyrightable expression from some of the training data. Right. And on the first question, so the fair use question, it's early days for most of the litigation, but we kind of got lucky because I think it was 2020, a lawsuit was brought by Reuters against this AI company that was trying to create a new kind of AI tool for lawyers where you can put in a question and instead it will give you just basically a quote from a case that it thinks is relevant to what you're trying to determine. And in doing that, it wanted to train on this basically Westlaw head note. So Westlaw is a tool that lots of lawyers use to find cases and stuff like this. It's basically a giant database. But one of the things that they do is they create these little kind of like, so I always thought that they were just verbatim quotes from cases that you could just click on to get down to the point in the case that was relevant. But apparently sometimes they're not verbatim. Sometimes they make slight tweaks to them. Those were scraped and used to train the model in the context of all of this stuff. And the defense was fair use. Both sides wanted the court to just immediately say that they won at summary judgment. And the court, for the most part, just said, I can't make these decisions. It's going to have to, almost all of it's going to go to the jury because there are a lot of factual disputes that need to be resolved and the jury is going to be able to do that. But what the court essentially said was if the defendant, if Ross, this AI company, was making these reproductions in order to create this tool where the tool was intended to only output non-copyrighted parts of cases, then its use of those materials in reproduction for training was a fair use. It just sort of said that in this like black and white way. That was very good for the people who want it to be fair use because that's the first time you have any court anywhere basically opining on whether or not it's going to be fair use. And so we have that. And now the question is just whether or not the jury will find that that was what the purpose was. It seems like that will be found because the whole point of this tool, as I understand it, was to give quotes from cases, right? And that's because when you're evaluating fair use, there's a list of statutory factors that you have to consider, and then you can consider other factors, but there's 4 factors that you have to consider. And one of the things that has always been very important, at least sort of in more recent times, is whether or not the use was transformative. And that's under the first factor. And the court was just very clear that this was a transformative use. You're taking a head note, which is basically like a summary of like a part of the case, which that's one thing. And you are using it, it's being totally transformed in essence to make this totally different thing, which is this tool that will allow you to generate pieces of cases, right? And so that's really where a lot of the action is whether or not it's transformative.
And that has moved in the last 20 or 30 years, right? You know, those early Beastie Boys records, which they could never clear because they have so many samples that you can't recognize, but nonetheless are samples from other songs, other works. Now they would probably say it was fair use because you couldn't recognize them, but back then they couldn't get away with something like that. You know, if I want to make a Beatles song, right? Like, let's say I trained a model that listened to all the Beatles songs, and I said, make me a new Beatles song. And we haven't heard any of these yet. We keep hearing about how we're going to have all this great new music by artists who aren't around anymore, but it all just sounds terrible. But, you know, I'm not sure Miles Davis' estate really needs very much to worry about at this moment in time. I'm sure it'll get better. But, you know, we don't know how the computer makes a new Beatles song. It may have to use pieces of all sorts of things because we don't know how the model's trained. You know, what we're counting on the model to do is to bring us to a point it hasn't necessarily seen before. And so the Sarah Silverman thing is sort of black and white in a way, but a Beatles song has infinite more complexity to it. It may sound like, it may have a little Rolling Stones and a little Rod Stewart, whatever. It could have a whole bunch of other things mixed in there. How can we identify what's in the model that is actually copyrightable?
Those are some interesting, hard questions here. So
that's why we're calling you Heather.
I'm like, what do you think about the answer to this question?
Yeah.
So one of the questions is, what is basically retained from training data in the model, basically, right? And in some of these cases, the plaintiffs have argued that basically compressed versions of all of the training data are like in the model. And that's just like not possible. Because we're talking about billions and billions and billions of pieces of training data. There's not like space. It's just like, it is like not possible. But something is happening, right? Because the training data is basically teaching the model basically how everything relates to each other. What should I expect to see in this kind of a context? Because I've seen like everything on the internet that's ever been created, right? That's what it's trying to do. And so it's just hard to say what that is. I mean, in the end of the day, it's just numbers, right? It's a bunch of parameters and they're just like these numbers that don't mean anything to any of us. When we try to understand, like, is there copyrightable expression from the training data that is somehow kept in the model? If there is anything like that, it's surely not going to be in any way that we are imagining, like there's some mini image of this thing somewhere. And like, that's just not what's happening, right? So that itself is a very hard question, but it's actually really important because in order for the outputs to even be infringing, the model has to have had access to the copyrightable expression at the time it created the output, right? So in other words, like imagine that by some miracle, I never, ever heard of Harry Potter. And I never knew anything about Harry Potter. I never read it. Imagine we're like in an Eternal Sunshine of the Spotless Mind situation. Everything about that has been deleted from my brain. And then let's say by some fluke in the universe, I write a story that is substantially similar to Harry Potter. That is not infringing. In fact, my story could be identical to Harry Potter and it's not infringing because you can only infringe if you are taking a copyrightable expression from another author and using it in your work.
In that scenario, in order for you to have written it verbatim, it would have had to have been put into the model, your brain, and maybe you forgot about it. But the point is, it was put in there verbatim. So it is actually, doesn't it belong to somebody else?
Yeah. So you might just say, this is not possible. The chances of you not having any access to Harry Potter and writing Harry Potter is like impossible. And that's true. Like the chance that gets basically one in...
Well, statistically improbable.
Yes, it's statistically... highly unlikely, right?
Yeah.
But this is, people say this idea of a bunch of monkeys with a typewriter in a room, which is
Sure.
like if you leave them for infinity, eventually. I don't think it's necessarily true, but that's the idea, right? So that's what I'm imagining. But what you're mentioning is, okay, but like we all hear lots of music, we read lots of books, like things are in the ether. And if I infringe, it's not like I need to have Harry Potter like in front of me to infringe. Right now, I have retained copyrightable expression in one way or the other in my brain, then I can then go make things that are infringing, right? So this is another thing like our concept of authorship, where our concept of access, which is required, is just not particularly clear because we've not really ever thought about it. And we've never had computer programs that were capable of making stuff. It's always just us. And we all understand that you could remember a tune and you're, in some sense subconsciously, even if you don't have sort of immediate access to it. But in the case of these models, in theory, we can understand what it did have access to when it was making something and whether or not it actually had access to copyrightable expression. The problem is we don't know how to do that. Like, we don't really understand how to explain that right now and what it means. But there are a lot of AI researchers who are working on these kinds of questions.
We don't really understand memory in the large language model, right? We don't understand what it remembers. I can go to it and have exposed it to Moby Dick, and it can tell me a pretty good synopsis of each chapter. It can tell me the issues that are going on in the book, the characters in the book. But if I say to it, what happens on page 245 of the Dover edition of this book, it has no idea and it can't do it. It might give me some nonsense answer, but it really can't do that. If I'm using Moby Dick to make a creation like Moby Dick, is that like I'm reading Moby Dick and coming out with something that's exactly like it, even though the computer doesn't remember it that way?
Yeah, I mean, this is the question. I do think that in the end of the day, the point of this training is to train a model to understand, like being able to make predictions, right? I just think of it as this alien thing that understands the world in such a radically different way than us, which is just this relationship of probabilities between different concepts, different words, different things, right? In a way that is just it's totally alien to the way that we think about stuff, right? And so my understanding is that in the cases where it is able to give you like a summary of a book, that's because it's seen that a lot of times, right? I mean, if you see one piece in a billions and billions and billions of training data, you are not going to be able to predict like what should be coming next and what's the explanation of this thing because you saw it like one time. But if you see it many, many, many times, then you start to get a sense of like, oh yeah, chapter 1 of Harry Potter has this. Chapter 2 of Harry Potter has this, right? So that's like part of the difference. But yeah, so then the ultimate question to me from a copyright perspective with an output is even if we assume it's been trained on all of these copyrighted works, in order for me to know whether the output is infringing, I just need to see, like, is there copyrightable expression from something that you can identify as a base? And in most of the cases, the answer is no, right? And then we get to, like, maybe there are a few cases where you do see something that looks like copyrightable expression. And then you get to the question of, okay, well, was it actually trained on that? And then we get into these weird access questions of, like, well, what is it retaining? Does it really have that? And those are really interesting. And I think just technologically, yet we don't have an answer for it. But I think one of the key things that people have, like, who are not sort of, dealing with this on a day-to-day basis, is that the outputs should only be infringing if it would have been infringing if a person made it. Right. So, like, if I made a thing that was like a derivative work of Harry Potter, it would be infringing. If it comes out of, one of these models, right, it's like the same thing. But it's not this mysterious thing where every single output is a derivative work of every single input. Right. That's not how copyright works. It's about protecting expression. That is the first part.
So what is at the heart of that is attribution. Right now, we don't really do much attribution. I mean, with OpenAI, it'll look at Bing and it'll sort of tell you where it got some of the answers, but it doesn't have attribution on every single line of text. Is that something that's going to have to really be traversable? And I'm sure those guys over at OpenAI do not want to do that because there'd just be a lot more question, a lot more algorithms to have to do that,
Yeah. I mean, so I think one of the difficulties is that, last time I checked, there is not a way for the program to go back and say, I know which parameters sort of weighed in the most in why I gave this output, right?
Yeah.
What Bing is doing and what all these things are doing is a little bit like weird. It's not saying I actually use this website in order to come to this conclusion. Like, this output is just me copying something from this website. After it generates an output, it's then searching the web saying, like, what looks like it's related to this. And then it's citing that, right? But that's actually not a citation to what was used, right?
There's also this idea of intention as well. And how do you even put law to an intention? Because if you're willingly trying to recreate, hey, put the prompt into ChatGPT, okay, write me a Harry Potter story, it will give you a facsimile, right?
I think what you're saying is, like, well, what did the user contribute in order to get something that, let's imagine there's an infringing output. Like, what did the user do? So interestingly, that wave of cases hasn't happened yet. The wave that we are dealing with now is, like, is training a model in the beginnings fair use or not? We will certainly have those cases as well. And that would be an interesting question about who's responsible as the direct infringer for an output, right? Is it the user? Like, well, if the user's putting in, like, a bunch of stuff to basically circumvent every single filter that's been trying to get it to do, like, not infringing outputs, then it looks like the user is really the infringer, right? But that's a question.
Right.
But on the attribution question itself, I mean, this is sort of my own personal view, but I have a couple of different thoughts about this. One is, if we have outputs that are sort of the result of a model that was trained on everything on the internet, the idea that we're then going to give attribution rights to that is a little bit weird to me, because we don't do that in our normal day-to-day basis, right? I mean, if I'm, like, actually quoting from you, generally the idea is that I'm going to cite you and say that. But if the whole history of my life has resulted in me having certain kinds of views or writing certain, I'm not going to, like, give a bunch of attributions on that, right? There's a certain kind of fetishization of attribution that can happen that I think is very bad. Bad because I think it's practically impossible, but also bad because it's just not the way that we work, for good reason, right? So I hope that is not what happens. It's a different story if you are creating something and it is something that was made to directly take from something, right? Then that makes sense, because you might want attribution, A, because it's useful to know, and B, because, like, you are attributing something that was in fact should be attributed, right? But in most of these cases, it's not like that at all. It's like what you were imagining before, which is that it's trained on a million things, maybe in some infinitesimally small way that contributed to what the output was, but that's not a place where we usually would say that we would really give attribution.
Originally, copyright came in, I think, around Stephen Foster's great, American songwriter, and the reason it came in is because, he made all these songs that contributed to America, and the only thing he could do was sell his sheet music, and then other people stole the sheet music and they started to do it. So that's what it came in around, right? And I think it was originally only 27 years, and now we've gotten it up to, a lot longer. I guess my question about it is, has the copyright law kept up with where we're trying to go?
Well, the Copyright Office is trying to figure it out right now on the ownership piece. and lots of other questions about things. There's the question of what are we trying to achieve with copyright protection in the United States? And different countries have different philosophical justifications for their intellectual property law. In the United States, it's actually in our Constitution, the Progress Clause. Basically, it's a public benefit utilitarian calculus, which is that we're going to give you these rights for a limited amount of time, but we're doing it not for your own personal benefit, but because we think overall society is better off if we give you these incentives, that we'll get more good overall than if we lived in a world where we didn't give authors these kinds of incentives, because maybe then they don't have the incentive to create, right? And fair use is a part of that calculus, right? Fair use is supposed to be another way for courts to make sure that that balance is being recognized and acknowledged in the law, so that when you do, and this is why transformative uses are so important, which is that if you have the use of someone's copyrighted materials, do something that is just so in the public benefit, that is just like overwhelmingly, it's just transformative, then the idea that we need to give people a copyright protection to stop that incentive is needed is a much harder sell, because the whole point of this was to benefit all of us, right? And you just can see in this particular use case that there's just so much overwhelming benefit to everyone else in an area that that author was not before, right? So to me, I think the question is, how are we really going to view artificial intelligence? How are we going to view generative AI and the future uses that we have as a public benefit? And when we are using people's works in order to train that to do a completely different thing, like recognizing that the trade-off is worth it for the public overall.
We've talked about a lot of use cases that are entertainment. What about when we see things like seeds being copyrighted? You know, Monsanto, they could have just done it all as patents, but they didn't. Part of it is copyrights. Like, I don't know much about seeds, but when they make certain kind of seed, they don't want others to use it because it costs them so much to develop the recipe. Do you think that's a step forward for copyright? You know, do you see other kinds of use cases that are out there like that?
So when I think of Monsanto, the only thing I know about is the aggressive use of patents. I'm not aware of any of their use of copyright, but I will say that the idea is that there's copyright in a recipe. I will just let everyone know that because that, in some sense, it's an idea, right? An order of operation, like a recipe. As long as you just take out the copyrightable expression from that, you can't copyright an actual recipe, right? You can't copyright, like, that's just the way that you make a chocolate chip cookie, right? Like, you know, if I add my own little like flourishes in my cookbook about, you know, when I was a kid, when I made cookies with my whatever, that's like expression. That's protected.
Although I can copyright choreography, which is my expression of a recipe in some sense.
Yeah, so there is a case about choreography and copyrightability of choreography, which is a very complicated situation. And the idea there seems to be that you can't copyright a particular move, but in some sense, it's kind of like a compilation, right? Like, I can't copyright a particular word, but in some sense, my copyright over my novel is just kind of like all of the words and the expression and the characters and all this stuff that I built out. And so I think that copyright for choreography is kind of like that, but the decision that just came out when that takes some parsing. But other than sort of the kinds of, you know, movies and music and books and the kinds of things that we usually think about with copyright, are there other areas of sort of intersection of intellectual property and AI that I think are going to be really interesting? There is a lot of talk about the patent space with AI that I think is not, you know, there's a little bit of talk now, I should say, but really it's going to become more important. And that's because as it has to be a human author for copyright, you need a human inventor for a patent. And so as there have been these kinds of like quasi-test cases in copyright, there's been this like quasi-test case in patent. And the question was, could an AI be an inventor? And the answer is like, no. There's like no. But the real interesting question is, well, how much can I use an AI tool to help me invent something? And I'm still the inventor, right? And this, I think, is really important, because I think one of the most exciting uses of AI is going to be in health, in basically drug discovery, in health, right? You know, it can understand things that we don't, like, it will see connections between things and that we just don't see, right? And that is like very exciting. But if companies are worried that if they use these, you know, super awesome tools to help them identify new targets for drugs, or they help them make a new molecule, that then they can't patent it, that's going to be a real big problem, right? Because that is the way that they are able to make money off of their drug. Now, maybe we will radically transform the way we do things, but until we do that, like, we want them to have incentives. And I also want them to have the incentive to like make the drug as fast as possible, right? Like, I want you to find the solution as fast as possible. So that, I do think, is an area where I hope that we figure out a way to incentivize properly pharma companies and biotech startups to use whatever tools are available to help all of us as fast as possible and benefit us both in terms of the advancements and also hopefully the price, the cost and that sort of things. And that needs to be figured out is I think, actually very important.
Isn't it in certain circumstances that companies are actually considered people?
Yes. Maybe you were thinking of this case called Citizens United. That if
that little case, yeah.
That little one. So this is related to these things, which is that in the United States, if you are an employee of a company and you create a work of authorship while you're in the scope of your employment, the authorship instantly vests in your employer, which is like a company, right? It does not vest in you. This is very weird because otherwise it goes immediately to you, right? This is also why, for the record, like you also see these work for hire agreements that everyone wants people to sign, because the idea is if it is a work for hire, it immediately vests in that entity, right? So one of the arguments that was made when this particular person went forward and tried to say that the AI tool that he had created was the author of a work that was generated by the tool was that human authorship is not required because we have the work for hire doctrine and companies are authors of works for hire. Therefore, human authorship is not required, and therefore AIs are authors, right? Which is like a kind of interesting point you make. But the difference is that in order for it to actually vest in the employer, you actually do have a human author, and a human created it, and that's what makes it protectable. It's just that in this context, it then sort of immediately vests in a different person than the author. But there was an author in order to make it copyrightable in the first instance. So that piece at least won't be a problem. The problem is going to be how much do you need your employees to be involved. And this also came up with the strikes, the actor strikes and all the Hollywood strikes that are going, I guess, have been going on, which is why I was like, I wish I knew someone to talk to because they was like, if these companies choose to use AI to sort of write their scripts and they just don't use humans, they're going to be in for a very bad surprise when they realize that unless the Copyright Office changes its position, they have no copyright protection in that script, right?
Right.
Get out there and start talking. Seriously.
This is a whole other thing where I was like, I wish that people understood that if they did this, it would be very, very bad for them.
What happens when we take a great author and we say, okay, well, it's nowhere near this point now, right? But you could say to it, I want another book from X, and it generates the book for me in 2 minutes, and it's great. And it was my idea and my prompt. The book will be about this and this and that, right? Doesn't that have to be under the same thing as Stephen Foster? Isn't it that I'm a starving artist and I need to be able to copyright that?
Okay, so a couple things. So basically the question is the copyrightability of works that are basically derivative works or fan fiction, right? And this happens all the time, right? You like a story, you like characters, and you wish that you could just sort of chain the author in your basement so they had to continue to write it forever, right? And you can't, so everyone makes up their own and they share it, right? So the question there is whether or not that's a fair use, because it's definitely going to be infringing. And the reason that it's infringing is because, among other reasons, characters themselves are protected by copyright in the United States. So for instance, Harry Potter, the character is protected by copyright. So if I make my fan fiction with Harry or Luna Lovegood fan fiction, and Luna's in all my stories, then that's just infringing on the character of Luna, right? So if I do that with the models, right, and I make these things, well, you definitely use those characters. So is it going to be a fair use? If I went out and tried to sell that story, if I sold my Luna Lovegood stories, that's probably not going to work out very well for me.
Okay, but that's if it's within copyright. What if I took an author who's been dead for a long time?
Yeah, public domain.
Yeah. What if I did another version of Count of Monte Cristo, and it was good?
Don't start doing that, Jesse.
I'm not going to spend any time on it, I promise, but I'm just saying.
I mean, this is the question, is how much do you have to contribute in order for you to be the author of the work? And
right.
Nothing that you do, you're not going to be able to take anything out of the public domain, right? So if Sherlock Holmes is in the public domain, put using AI aside, you can make a new Sherlock Holmes story, which will be protected by copyright because that's a new work of authorship. But the character of Sherlock Holmes, the public domain one, that's still usable by all of us, thankfully, right? But say for purposes of this, that you want your particular Sherlock Holmes story to be protected by copyright. The Copyright Office needs to make some decisions on this. But I will say that my sense so far has been that people have very strongly different intuitions on what it means to be the author of a novel or a story versus a piece of art.
Am I under obligation to tell the copyright office that I used ChatGPT to help me write the novel?
Morally, you are.
So if you want to register the work, then the answer is yes. And it's made this explicit. And the reason is that you have to disclaim, and now they actually care about this, you have to disclaim the non-copyrightable elements of the work that you are trying to register. And so if you don't do that, and they find out later, it comes out that you used AI, and it basically contributed more than a de minimis amount to the work, then they'll just like invalidate your copyright.
Interesting.
This also comes up with the movie industry, right? Because if you submit and you don't disclaim the AI pieces, and then say somebody infringes your copyright when it comes to damages and statutory damage, if it turns out that your registration is invalidated, that's like a big deal, right? And so they have to disclaim the pieces, or else that will be absolutely used in future litigation. And so, yes, you have to disclaim it. The thing that is hard to know is like, what if you are taking the position that there's nothing to disclaim because you were the one who, sufficiently controlled whatever the tool in the way that you control a camera, right? No one's disclaiming when they're putting in an application to register a copyright for a photograph, right? But the camera or whatever, your phone, does a lot of stuff in that process, right?
Right.
But we don't seem to mind that piece. So people are saying, why is it any different with, like a Stable Diffusion or a DALL-E or whatever, right? That's the thing that's being debated right now, and that there's just not a clear answer on.
What if you are the author of Harry Potter, since that's your favorite, seems to be, example, and you actually ask the tool, could you write me a sequel? But it's your own piece of original authorship. Where does the copyright go down on that? And how much ownership would you have?
Yeah, so this is also a great question. I would use my favorite character, which is Panin, if you've ever read Panin. But no one knows who Panin is, so it never works. But everyone knows who Harry Potter is. But yes, I did this for a client once. I used like all my Panin examples, and they were like, who is Panin? No one says, who is Harry Potter?
Yeah.
But I guess what I would say is this. You continue to have copyright protection in your characters. So nothing about that makes that a problem.
Okay.
Other than that, as the Copyright Office is treating it right now, if you put in, like as a prompt, as just an example, like if you're J.K. Rowling and you say, write me a story about what happens to Luna Lovegood after she leaves Hogwarts, in the next 5 years of her life, and make sure you include like one, this one thing or whatever. The Copyright Office is going to say that you did not contribute any new creative expression beyond what you already had a copyright in before, which was the character of Luna. And so you still have copyright in Luna, but all the story, the expression that you'll see in the story that's being told, that's not yours. And so you're not going to have protection over that. But what's interesting, though, is that doesn't mean that everyone else can just copy and paste and reproduce your story, because your story has Luna in it, right? And so they would be infringing your copyright with respect to Luna, even if you don't have protection in the other pieces. So this is why there are ways in which you can use these tools if you have pre-existing works that will, in essence, like you won't get any new protection, but your old protection, it kind of like insulates you from some ways of it being used in ways that you would not want.
Wow.
We're lucky that human beings have spent so much time writing things down that we have our ability to make these big models. We have 1,000 years of books and things that can get thrown into these models. For the next Picasso or the next Miles Davis, for the art that's really on the highest level that we want to keep inspiring ourselves and learning from, and there's not much of it really. It's like if you add it all up, there's maybe 10,000 people out of 60 billion people who've made these things, and they're going to see these tools that are being designed every day, and they're just going to go, wow. The next Picasso is going to look at that and say, well, geez, I'm going to make a piece of art that nobody's ever seen before because I have these tools. Are they going to have a rougher road, or by the time that person is here, the next Frida Kahlo is here, will she be able to take these tools on a creative level and be able to protect herself so she can, like Stephen Foster, keep the ideas of her goods, the things that inspire us?
I think that people have already been using these tools in just absolutely incredible ways to make absolutely incredibly creative works. And I think that the people who come in the future and want to use these tools, and I think over time we're going to have more and more control over these things when we want to, such that it's going to start to feel more and more like a tool in Photoshop that's not a generative AI tool, than this sort of magical mystery thing. I think it's going to be less like that and more just like another tool. And then I think that it will be easier for copyright protection to extend to those things. And I think that another reason is that I suspect that there's just going to be a lot of lobbying going on by very powerful players, particularly in Hollywood, that care very, very much that their use of AI, which has been going on for many, many years, does not have a problem for their own work. So I think that a combination of forces will result at some point in some way of understanding that some of it is protectable, and that those artists are going to be able to do that. Some people ask like a sort of separate question, which is whether or not the creation of these tools is sort of going to like disincentivize people from becoming artists in the future in the way that people thought that when
the paintbrush came in.
Yeah. But when an AI first beat like the masters in chess, human masters in chess, everyone was like, "Oh, we'll never play chess again." Or there was a camera, and then everyone was like, "Oh, you'll never have art again. It's just going to be like it's all downhill from here," right? I don't really subscribe to that view. I think that every time I see people's stuff with the they make with this, I just think I can't wait for like 10 years from now to see what people are capable of.
Yeah, I agree with you.
A long time ago, I was like, what is a better job than being like an animator at Pixar? And I was like, I will learn how to do, I think it's like Maya or whatever, all of their stuff. And I will like learn. It's so incredible what they do. And it's like super hard. But now you have some of these tools where people are making these just like amazing movies with just like, a lot of skill, but not the same level of requirement of time that used to go into just learning how to use some of these tools. And I'm like, it's like so much more cool stuff out there. And there will be so much more cool stuff out there because of that. So to me, I'm optimistic in that sense, but I guess we shall see.
Yeah.
We shall see.
Thank you, Heather. This is great.
Heather was so great. And there's a lot to think about as we continue.
Heather, we may call you with some questions.
Yeah. Thank you very much for having me. It's always fun.